He did a good job at bringing that out. In other words, that she was capable of consenting with a high BAC. But by this, I thought he was going to go towards that the witness was not credible because the witness found that she wasn't intoxicated, and yet she had a 0.13, which could explain teary-eyed, red eyes, a lack of memory, things that we typically would see like in a DUI case or anybody who's under the influence. So I don't know whether or not the defense lawyer's holding that powder for to argue in summation. But I guess in this particular case, he's trying to say she had enough wherewithal that this expert witness didn't even feel that she was under the influence. And certainly somebody who is under the influence could still be alert and oriented ×3 and, in fact, ×4. And I can tell you that as an EMT, and we all know that. That's the person, place, time, and event. Clearly under the influence, you can do those things. Right. The question is whether or not the level of intoxication robbed you of your ability to consent. People can have a high level of tolerance. Their enzymes are burning alcohol off at their liver at a very, very quick rate. And yet they can wake up the next day and have no memory of really what happened, or a distorted memory. That is your classic blackout. So maybe that's where they're going. A lot of times you could present an expert. You'd have to put a person on to say, this is the level of capability of drinking, and this is what the consequence could be. And the defense is arguing down the road. Of course, they're saying there was no sex at all, but they're basically saying she really doesn't have a memory of what really did occur. And I have to be honest with you guys. I've had cases where this has been said and it was wrong, and cases where it's been said and it turned out to be true, that the victim had a sense of something but later admitted, I really don't remember what happened. Every prosecutor wants objective corroborating evidence in any sex crimes case. This is one of the biggest issues that you deal with as a prosecutor. You want to either get a statement, a confession, physical evidence, DNA, electronic records. But if you don't have all that, in fact, we have a mutual friend, Judge, that tried a case just before COVID where there was none of that. And the prosecutor's argument was, look, I just believe her, and I believe the jury will believe her. And a lot of people are shocked at that. You mean to tell me it just could be he said, she said? Absolutely. And if the jury believes that person beyond a reasonable doubt, you could be convicted of it. In that particular case, the jury did not believe it, and the person was found not guilty. So as a prosecutor, you've got to be, at least for me personally, I was always giving the benefit of the doubt. I know people may get flustered at this, to the defendant, to ensure that I never made a mistake in a case and prosecuted and convicted somebody who may, in fact, have been innocent. I don't like the idea I don't have corroborating evidence in a rape case.